Hi, everyone. Mac Pierre here, attorney, mediator, and arbitrator. And welcome to the Lawyers and Mediators International live show and podcast.
And I am Natalia Olowska, advocate, mediator, and arbitrator based in Warsaw, Poland.
And I'm Fran Brochstein, attorney and mediator in Texas. And please remember, this is not for legal purposes. This is for informational purposes only.
I'm happy to welcome everybody again, including our listeners and those who will be watching it. This is the second part of the hints process non-lawyers should remember when attending mediation. And we are here to tell those who attend mediations without lawyers some more about what we consider important for the good and efficient mediation process for the parties. So what would we advise as a first part in the second set is everybody who comes to mediation needs to come ready to negotiate, have an open mind, and know what they want. What do you think about it, you two as mediators, Mark and Fran, and what are your experiences with it were?
Well, I think it's very important that people think about, excuse me, their best day in court and their worst day in court. After being an attorney 30 years, I have never seen a slam dunk case yet. Every case has some good points and some bad points. And I encourage people to make a list of the essentials that they have to have, what they'd like, and lastly, maybe what, a wish list.
So when I think about parties going to mediation and needing to have an open mind and needing to be ready to work, I think that it's the parties to remember that it's their case, right? That mediators can only offer suggestions. Okay? We can only give not even recommendations, but facilitate the discussion to move it towards a direction where people see that there are other options out there for resolving their dispute. But ultimately, the power lies in the hand of the person. Okay, so whenever it comes to reminding people about court and how court differs from mediation, I like to tell people that, look, think about what your best day in court looks like and what your worst day in court looks like. All right. Don't expect the other party in the other room, maybe, who's your opponent. Don't expect them to make a deal with you today that's just going to mirror their worst day in court. Because if I say this, sometimes if they're going to get screwed over, they'd rather get screwed over by the judge, not by themselves. Okay, no one's going to just agree to, commit malpractice upon themselves and give you everything you want. So you have to be expecting that there's going to be negotiation, that you're not going to get every single thing you want, that the other side is not going to get anything they want, but they're going to get something in order to reach a compromise, in order to make a deal that both people can live with and accept. So there's, like you said, Fran, there's not a slam dunk in court, and nor is there likely going to be one at mediation, as well. Unless, of course, I guess the case is so extremely black and white that there's no other way, to resolve a dispute. But in my experience, most of the time, parties need to just come to mediation with an open mind and ready to actually do the hard work of negotiation.
This is why I think that when coming to mediation, being without a lawyer, you need to prioritize your issues in your head. You need to know what's most important for you. You need to know what you can either just embrace or it can also wait for, let's say, second mediation session. So the priority of your issues is also an important part of it all.
All right. So moving on to number 2, the next tip is, or the next hint is, don't be afraid to understand that the mediation session does not have to wrap up in one session. Okay, a mediation session can last multiple sessions. Okay, you are in the control of the mediation process. Now, well, the mediator is really in control of the process, but you ultimately have the final say about what you will or not agree to. And you also have the final say on whether or not you want to extend this thing. And so too many parties come to mediation with the attitude that, you know what, this is it, end all be all. If I can't negotiate today and be done, I'm wrapping it up. But you are in control to be able to extend this thing and continue the process until the parties have exhausted all options to help a resolution come about.
Yes, Mac. In our last session, we discussed that a mediated settlement agreement is binding and cannot be revoked. And so many times when I'm working with people without attorneys, if they want to go home and sleep on it, think about it, review it, and come back for a second or third session, I have no issue with that at all. Of course, they pay me for the extra sessions, but in the long run, I find that I have saved them a lot of money instead of litigating it, and they are happy and very confident that they've entered into a fair arrangement for both of them.
And this is also what I would say. Sometimes you need to simply be patient about your outcome. Know that sometimes you need to rethink, reconsider, and sometimes even use external help, which can be the reason for resetting and rescheduling your mediation session. So the third hint we want to touch on today is about the role of mediation and in the court process. And our general remark on that is that judges love mediation. What do you two want to say about it?
Fran, go ahead.
In Texas, but almost before you could ever get a trial setting, you've got to mediate. That's become pretty standard. Many judges will not even have a temporary order hearing in a family law matter until you've attempted mediation. So many times people come to me at the beginning for a temporary agreement. Sometimes we meet after several months and then revise it. And then they come back a third time and we do a final.
Yes, and I love judges who love mediation, okay? Because a lot of times people don't even know what they're fighting about. They just know that they were wronged by the other side and they want justice. But most of these cases we're mediating, I would say, in my situation, all of the cases we're mediating don't involve criminal prosecution. Okay, we're not doing criminal cases here where you're going to go to court and get justice from a jury. You're dealing with things that are a little bit more gray sometimes, a little bit more nuanced. You're dealing with children. You're dealing with money. You're dealing with, assets and he said, she said a whole lot. And so sometimes it's not that black and white. This is why there's so many people who counter sue each other back. You sue someone, they sue you back. Happens all the time in family law. And so, or in civil cases as well, because people think they have a claim. Well, those kind of cases are made to be negotiated. Doesn't mean they're going to be resolved at mediation. That's fine. But at least if people are forced to talk and discuss, and this is why good judges send parties to go negotiate, to at least assess the issues, okay? See what you guys are really fighting about. What are the terms where you guys can't see eye to eye? Because I bet you there's usually in a multi-issued case, there's something you guys do agree on, right? I mean, almost always both parties agree that we both love our kids, right? There's some things that people just, yes, it becomes a black and white issue. Okay, is she gonna get the rocking chair or are you gonna get the rocking chair in the divorce? Like, I got it. We're not gonna cut the rocking chair in half. Someone has to win it. But even that, there can be, some give and take to negotiate a settlement. And I know you've negotiated rocking chair before, right, Fran? But I mean, we all have. They always seem to come up in divorce cases, rocking chair. It's happened to me, literally. And so I would say, remember, the judges love mediations. Good judges love mediations because they realize that not every single case needs to go in the first instance right in front of the judge. Sometimes they need to be discussed first between the parties, at least at good faith, to make an attempt to negotiate, but without a guarantee that it might actually resolve the whole issue.
Well, we have never discussed this, but probate court loves mediation because oftentimes it's hurt feelings regarding the will or division of the estate, as well as judges hate hearing cases with what are we going to do with mama who needs to go to a nursing home. And they really send those families to mediation because those issues should not be decided by a judge. Those should be decided by the family.
Yeah.
Thank you for that. And I also want to say that mediation is the place where you can go far beyond what you filed for in the court. This is where you can be far more flexible. You can regulate things that the judge in the case that is pending doesn't even know about. You can regulate things that would even sometimes be not enforceable, but at least you agreed upon them. Like, for example, introducing the new partner in life into the life of your kids. It's not going to be enforceable in any way in the court, but you can agree that you as a parent, you as a mother or father, you will know that your ex has someone new and that your kid will not come back surprising you. Hi, I have a new uncle or a new aunt. So really, even those steps are so things that really hurt you deep in heart, and you will not have a place to speak about it in the court. And judges know that very well, that there will be those issues that they will not even see in the court case. However, when they are regulated by the parties themselves, that can ease the entire upbringing process for the kids so much. And this is good why good judges love mediation.
Yes, and before I go to hint number 4, one more remark about this. Natalia just brought up some of the sensitive topics that are better handled at mediation instead of in a courtroom. I think of 2 more. One of them that's very common in Texas are morality clauses. A little less and less, done these days. But a morality clause where you don't want, your new girlfriend or your new, partner to be spending the night, all right, around these children in an ongoing divorce case. And so you want some kind of morality clause to be put into the divorce decree or the temporary orders that basically said, look, for the next number of months, neither of us are going to be having our new boo around the child because we don't want to confuse the child. Well, a lot of judges, they don't really have a whole lot of time for this, okay? These are things that come up and that should be negotiated and discussed at mediation. The other issue is right of first refusal, where you want to have the other party to notice you before they take off for the weekend so that you get the chance to spend time with the child instead of the child going to some stranger. Again, these issues, sometimes a court might see them as petty because they just want to give you the standard stuff, okay, and then say next to the next case on their docket. But more reason to go to mediation, just because it's that's the place some of those issues should be resolved. All right, hint number 4: research your mediator. All right, qualify your mediator. Each mediator is different, and you need to know what differentiates them one from the other. You need to understand why this mediator might be a perfect fit for this kind of case and another one not so much. Thoughts?
Well, in Texas, not all mediators are attorneys, and a lot of people don't understand that. I have worked with some non-attorney mediators that were exceptional. And then on the other hand, in Texas, we have no regulatory authority. There's no government agency regulating mediators. So I call it the wild, wild west. In Texas, you're required to take the 40-hour mediation training. And if that's what you want to do, that's it. If you want to do family law, you're supposed to do another 24 hours of training. But there is no governmental agency that regulates that. And each state and each country is different. I won't mediate outside of Texas because there's some states that have different rules and they have laws that regulate mediators. So to be careful, I just don't go outside Texas.
And thank you for that. Of course, mediation is about your family issues, but sometimes, for example, when I have, as an attorney, people are coming to me and I know that they have really, really small kids and I can see how little they know about these kids, I would direct them to a mediator who is having the child psychological skills. That means that they can be a therapist themselves. They can be just qualified to do those things, because, of course, mediation and mediator doesn't give you advice, neither on law nor on how to upbring your child. However, when someone with enough expertise is able to put certain light on the aspects you are bringing to mediation, or on the position that you are making and how it can possibly, for example, be detrimental to your kids. And caution, the mediator will not tell you that. The mediator will simply ask you certain questions that make you realize that you are wrong yourself. But this is a very important process of learning that can also happen in mediation. So yes, there are quite a lot of good mediators out there, but there will be some who will be better for your case this very time. There will be some that are better for your case some other time, or better for another case.
All right, Natalia, you got number 5?
Yes, with pleasure. So this is going to be controversial, but you have to be honest and truthful in mediation and disclose everything that is subject to, for example, division of property within this particular mediation. And Fran, will you tell us why do you think it is so important?
Well, I'll share one of my funny stories regarding this. We did a mediation with attorneys, a very high-end family in Texas. And at the end, I include a statement, because I've learned the hard way, that any undisclosed assets are divided 50-50. And as the man was about to sign, he said, "Oh, we never discussed my ranch in the Texas Hill Country." Turned out that ranch alone was worth over $1 million. His soon-to-be ex-wife knew about it, was in the room laughing about it. So we then had, after our 4 or 5 hour mediation, had to totally renegotiate everything, because it was another sizable asset. So I encourage people up front to come, if they're not willing to make full disclosure and share their assets and their debts, then mediation may not be appropriate for them at this time.
Yeah, and one reason people can feel comfortable to go ahead and trust that the system works, that they can disclose, assets, and they can speak and get whatever it is they got to get off their chest, is because everything is confidential. Mediation is confidential, so you know that it's okay. What happens in mediation stays in mediation. So I'm not gonna fear that what I've just disclosed is gonna then come back to haunt me. Natalia?
Yes, and however, please remember that this confidentiality that you are covered by will not be absolute in 2 cases. Fran, what are these cases in Texas?
And it may be different in other states and other countries, but in Texas, if there's elder abuse or child abuse alleged, the mediator is a mandated reporter and must contact Children's Protective Services immediately. That has come up in a mediation. Her attorney asked me to step out, and when I came back, she said, I said that in order to see if he would never have access to the children again. So she backpedaled. But I mean, I basically said, I'm a mandated reporter. I've got to go report this to CPS. And the attorney freaked out. And eventually the woman did not understand what she was saying.
Yeah, that's very important, because we want to protect, folks who can't protect themselves.
Right.
Yeah.
Anything else to add, guys, to that?
No.
All right. So hint number 6, mediation is a process, and sometimes a very slow process. Understand that. The analogy that's in my head is making really good stew. Okay, have you ever used one of those crock pots that you put all the vegetables and your meat and all that stuff into it? That's some good home cooking right there. But the only problem with that, it takes forever. I mean, it takes like all day. So if you're hungry, you don't go use a crock pot to make your stew, right? You go to the microwave, get a pizza. But I love that stuff. But when it's made, I mean, it's a perfect dish, right? That's ready ready to eat. So I think mediation is like that, right? It takes time. It's very slow sometimes. So I know in Texas, we typically have, well, where I typically practice a lot of times in Houston area, we have these 4-hour mediations and these 4-hour blocks. They become pretty popular. And so people, we don't even say 4-hour blocks anymore. We just say AM or PM. AM means 9 to 1. PM means 1 to 5. And so it's whichever block the mediator and the attorneys and the parties can, meet up at. And you're expected to do the 4 hours that you've paid for. And the danger is that people start thinking that if the mediation does not settle within that 4 hours, then it was a complete waste of everybody's time and it will never settle. But that's not necessarily the case. It can be the case that the mediation, that particular mediation, just needs a little bit more extra time, a little bit more hand holding, a little bit more massaging. People need to spend more time discussing. Sometimes they need to sleep on things. Like you said before, Fran, go home, recess, come back. And so it's okay if it takes 5 hours or 6 hours or more. So don't let the speed of the process or expectations about what you might have heard about somebody else's mediation settling in like 2 hours. Don't let that be the borders that you operate within. Understand that mediation is a process and you need to let it have time to stew. See what I did there?
Excellent. I agree with you. I've always said that my job as a mediator is to stay out of the way and let the mediation process cook. Exactly what you said. It's like a fine stew. It takes a while for the flavors to come together. And Natalia, you need to sum up what they say in Poland because I thought that was priceless.
In Poland, the Ministry of Justice advertises for mediation, which is a promoted way to settle disputes, especially now in the times of the pandemics, where the courts suffer from increase of cases and backlog, especially in family matters. The slogan for that is mediation makes miracles. And we as mediators, with our experience, strongly believe in that. We've seen that many times. So there is no need to be afraid of mediation. There is a strong, very, there should be the openness, the readiness to try. You might not settle all in all, but at least try, see. Maybe there will be issues that you will understand better. What mediation also gives you is to understand the other party's motivations on many occasions. Whereas before you just thought she was stubborn or he was stubborn, they just didn't want to move forward from the position. But there might be certain grounds for that. And when you know these grounds, when you realize what's behind it, you might agree with them that they do have a point in that. So that would be all from us today. And remember, you can catch this discussion in any past and future shows on our website, instantmediations.com, or the Instant Mediations app. And we will be happy to have you with us again in another week.
All right. Thank you so much, Fran, for checking in again.
Thank you.